Question 1. During a major transformation where existing methods of handling jurisdictional issues are being reevaluated, a plaintiff files a lawsuit in federal court under diversity jurisdiction. The defendant, a corporation incorporated in Delaware with its principal place of business in Texas, moves to dismiss for lack of subject matter jurisdiction. The plaintiff, a resident of New York, claims $60,000 in damages. How the court ruled the court should grant the motion to dismiss because the amount in controversy requirement is not met. B. The court should deny the motion because complete diversity exists between the parties. C. The court should deny the motion because federal question jurisdiction applies. D. The court should grant the motion because corporations are citizens of multiple states, destroying diversity. Answer A. The court should grant the motion to dismiss because the amount in controversy requirement is not met. Explanation. Under 28 U.S.C. SS 1332, federal court has diversity jurisdiction when there is complete diversity between the parties, i.e., no plaintiff is from the same state as any defendant, the amount in controversy exceeds $75,000 exclusive of interest and costs. Here, complete diversity does exist. The plaintiff is New York resident. The defendant is citizen of Delaware Incorporation and Texas, principal place of business per Hertz Corp. V. Friend 559 U.S. 77 2010. However, the amount in controversy is only $60,000, which is below the $75,000 threshold required under 28 U.S.C. SS 1332A. Thus, subject matter jurisdiction fails. Why the other answers are incorrect. B. Incorrect. While complete diversity exists, the amount in controversy requirement is not satisfied. C. Incorrect. There is no federal question under 28 U.S.C. SS 1331. This is diversity case, not one arising under federal law. D. Incorrect. Corporations can be citizens of multiple states, but this does not destroy diversity unless one of those states is the plaintiff state. That is not the issue here. Question 2. While investigating inconsistencies across various units in a multi-party litigation, the court considers whether certain plaintiffs should be joined to the case. The judge examines Rule 19 of the Federal Rules of Civil Procedure, which governs necessary and indispensable parties. Which of the following best describes the standard for determining whether a party must be joined? A. A party is necessary if their absence would impair their ability to protect their interest or leave existing parties subject to inconsistent obligations. B. A party is indispensable if they are financially liable for damages. C. A party must be joined if they have any legal interest in the case, regardless of how minimal. D. A party is always necessary if they reside in the forum state. Answer A. A party is necessary if their absence would impair their ability to protect their interest or leave existing parties subject to inconsistent obligations. Explanation. Under Rule 19A of the Federal Rules of Civil Procedure, a party is necessary if complete relief cannot be accorded among existing parties without them. Their interest may be impaired or impeded if they are not joined. Their absence could expose an existing party to inconsistent obligations. If a necessary party cannot be joined due to jurisdictional or practical reasons, the court must determine whether the party is indispensable under Rule 19B. If so, the case may be dismissed. Why the other answers are incorrect. B. Incorrect. A party is not indispensable solely because they are financially liable. Indispensability is determined by factors such as fairness and procedural efficiency. C. Incorrect. Simply having a minimal legal interest does not make a party necessary. The interest must be substantial enough to affect their rights or expose other parties to harm. D. Incorrect. Residency in the forum does not determine necessity or indispensability. The analysis is based on legal interests and case impact, not location. Question 3. During an emergency response where multiple areas are impacted, a district court grants a preliminary injunction under Rule 65 of the Federal Rules of Civil Procedure. The defendant, arguing that the injunction was improperly issued, seeks an interlocutory appeal. Under what circumstances may an interlocutory appeal of a preliminary injunction be allowed? A. Interlocutory appeals of preliminary injunctions are never allowed, as only final judgments can be appealed. B. Interlocutory appeals of preliminary injunctions are permitted as of right under 28 U.S.C. SS 1292A1. C. The defendant must first file motion for reconsideration before seeking an appeal. D. Interlocutory appeals are only available if the trial court grants certification under Rule 54B. Answer B. Interlocutory appeals of preliminary injunctions are permitted as of right under 28 U.S.C. SS 1292A1. Explanation. Normally, appeals are only permitted from final judgments under 28 U.S.C. SS 1291. However, 28 U.S.C. SS 1292A1 provides an exception allowing interlocutory appeals from orders granting, denying, or modifying preliminary injunctions. The rationale for allowing such appeals is that preliminary injunctions can have immediate and significant consequences, requiring appellate review before final judgment, while the other answers are incorrect. Incorrect, while most appeals must await final judgment under 28 U.S.C. SS 1291 preliminary injunctions are specifically exempted under 28 U.S.C. SS 1292A1C. Incorrect. There is no requirement to file motion for reconsideration before seeking an appeal of preliminary injunction. The appeal is allowed as of right. D. Incorrect. Rule 54B applies to partial final judgments, not preliminary injunctions. Preliminary injunction appeals do not require Rule 54B certification. Question 4. During an emergency response where multiple areas are impacted, a federal agency initiates a lawsuit against a multinational corporation for environmental damages caused by hazardous waste disposal. The agency files the case in a federal district court, arguing that it has subject matter jurisdiction under federal question jurisdiction. However, the defendant corporation moves to dismiss the case, asserting that the federal lacks jurisdiction because the claims arise under state environmental laws rather than federal statutes. The agency counters that while the claims reference state law, they involve significant federal issues. Which of the following best determines whether the federal court has subject matter jurisdiction in this case? A. The case can proceed in federal court if there is diversity jurisdiction between the parties under 28 U.S.C. SS 1332. B. Federal question jurisdiction exists only if the plaintiff explicitly pleads federal cause of action under federal statute or constitutional provision. C. Federal jurisdiction is proper if the state law claims raise substantial federal issue that is actually disputed and necessarily raised. D. The court lacks subject matter jurisdiction because state environmental laws must always be adjudicated in courts. Answer C. Federal jurisdiction is proper if the state law claims raise a substantial federal issue that is actually disputed and necessarily raised. Explanation. Federal question jurisdiction under 28 U.S.C. SS 1331 requires that federal issue be necessarily raised, actually disputed, substantial, and capable of resolution in federal court without disrupting the balance of federal and state judicial responsibilities. Grable and Sons Metal Products, Inc. v. Dow Engineering and Manufacturing 545 U.S. 308, 2005. Even if claim is primarily based on state law, federal jurisdiction may exist if the case involves an embedded federal question with national implications. A. Incorrect. Diversity jurisdiction requires complete diversity and an amount in controversy exceeding $75,000 under 28 U.S.C. SS 1332. This does not apply unless the parties meet the diversity requirements. B. Incorrect. While federal cause of action must generally be pled under the well-pleaded complaint rule, Louisville and Nashville Railroad Company v. Motley 211 U.S. 149, 1908, the presence of significant federal issue within state law claim can still establish jurisdiction. D. Incorrect. While state courts typically handle state environmental claims, federal courts may adjudicate cases where federal law plays a critical role in determining liability. Question 5. In a case where multiple parties have different objectives, a plaintiff sues a manufacturer for breach of contract and negligence after a defective product causes injuries. The manufacturer then seeks to bring in the distributor and retailer as third-party defendants, arguing that they bear responsibility for the defect. The plaintiff objects, stating that the additional parties will complicate the litigation and delay proceedings. The court must decide to allow the joinder under the federal rules of civil procedure. Which of the following statements accurately reflects the court's authority regarding joinder of additional parties in this case? A. The manufacturer may join the distributor and retailer only if the plaintiff agrees to their inclusion as parties. B. The manufacturer may implead the distributor and retailer under Rule 14 if they may be liable for part of the plaintiff's claim. C. The plaintiff's objection prevents the court from allowing joinder under any circumstances. D. Joinder is only permissible if the manufacturer can prove with certainty that the distributor, retailer are responsible. Answer B. The manufacturer may implead the distributor and retailer under Rule 14 if they may be liable for part of the plaintiff's claim. Explanation. Under Rule 14(8) of the Federal Rules of Civil Procedure, defendant may implead third party if that party is or may be liable to it for all or part of the plaintiff's claim. This is commonly used in cases involving indemnity or contribution. The impleaded party does not to be directly liable to the plaintiff, only to the defendant if the defendant is found liable. A. Incorrect. Defendant does not need the plaintiff's consent to implead third party. The court has discretion to allow or deny the motion based on efficiency and fairness. C. Incorrect. The plaintiff's objection alone does not automatically prevent impleader. The court evaluates procedural fairness and potential prejudice to the existing parties. D. Incorrect. The standard for impleader is whether the third party may be liable, not whether the defendant already proven liability. Question 6. During a major transformation where existing methods for handling evidence have changed, a dispute arises over electronically stored information, (ESI), during discovery. The defendant in a class action lawsuit claims that producing requested ESI would be unduly burdensome, citing high costs and technical difficulties. The plaintiff argues that the information is critical to the case. The court must decide whether to compel production under 26 of the Federal Rules of Civil Procedure. Which factor is the most important in determining whether the court should grant the motion to compel discovery? A. Whether the requested ESI is proportional to the needs of the case and does not impose an undue burden. B. Whether the defendant can prove that retrieving the ESI would be financially impossible. C. Whether the plaintiff has already obtained other forms of evidence that might be sufficient. D. Whether the discovery request violates the attorney-client privilege or work product doctrine. Answer A. Whether the requested ESI is proportional to the needs of the case and does not impose an undue burden. Explanation. Rule 26(b)(1) of the Federal Rules of Civil Procedure establishes that discovery should be proportional to the needs of the case, considering factors such as importance, cost, burden, and availability of alternative information. Courts evaluate whether the request imposes undue burden or expense relative to the stakes. Case Tubuleg v. Odds Warburg LLC 217 F. D 309 SD NY 2003. B. Incorrect. Financial burden is a factor, but the defendant must show that compliance is not only costly but also disproportionate to the case's needs. C. Incorrect. Alternative evidence can be relevant, but it does not automatically negate parties' right to obtain critical ESI. D. Incorrect. Privilege and work product concerns are important but distinct from proportionality under Rule 26(b). Question 7. In a complex federal civil lawsuit, the plaintiff seeks to depose a high-ranking corporate executive of the defendant company. The executive argues that they should not be required to sit for a deposition because they lack direct knowledge of the case and have demanding professional obligations. The defendant files a motion for a protective order under Rule 26(c) asserting the Apex doctrine. What is the court's most appropriate course of action when determining whether to grant the motion? A. Automatically grant the motion because high-ranking executives should not be subject to depositions unless they personally handled the matter. B. Deny the motion if the plaintiff shows that the executive has unique, non-duplicative knowledge relevant to the claims. C. Require the plaintiff to first depose lower-level employees before allowing the deposition of the executive. D. Postpone the decision until after the defendant files an affidavit confirming executive's lack of knowledge. Answer. B. Deny the motion if the plaintiff shows that the executive has unique, non-duplicative knowledge relevant to the claims. Explanation. The Apex doctrine protects high-ranking officials from depositions unless the party seeking discovery shows that the official has unique personal knowledge that cannot be obtained from other sources. See in re. Bridgestone Firestone Inc. Tires Products Liability Litigation 205 F. RD 535 S. D. in 2002. Courts balance the need for discovery with the risk of harassing executives. A. Incorrect. The Apex doctrine is not an automatic bar to deposition. C. Incorrect. While courts may require lower-level depositions first, this is not a strict prerequisite. D. Incorrect. The court need not wait for an affidavit if the plaintiff has already demonstrated the executive's unique knowledge. Question 8. A plaintiff files a class action lawsuit in federal court alleging consumer fraud. The defendant argues that the proposed class does not meet the certification requirements under Rule 23. The plaintiff must prove that all Rule 23(a) prerequisites are satisfied before the court can certify the class. Which of the following is not a requirement under Rule 23A for class certification? A. The class must be so numerous that joinder of all members is impracticable. B. There must be questions of law or fact common to the class. C. The claims or defenses of the representative parties must be typical of those of the class. D. The class members must all have suffered identical damages. Answer: D. The class members must all have suffered identical damages. Explanation: Rule 23A requires numerosity, commonality, typicality, and adequacy of representation. However, class members do not need to have identical damages. They only need to share common legal or factual issues. Walmart Stores Inc. v. Dukes 564 U.S. 338 2011. A, B, and C are correct requirements under Rule 23A. D is incorrect because variations in damages do not automatically prevent class certification. Question 9. A federal district court hears a tort case based on diversity jurisdiction. During trial, a dispute arises regarding the admissibility of a certain type of expert testimony. The plaintiff argues that federal evidentiary standards should apply, while the defendant asserts that the state's stricter evidentiary rule should control. How should the court determine which evidentiary rule to apply? A. Apply federal evidentiary rules because federal procedural law governs all issues in federal court. B. Apply state evidentiary rules because the case is based on diversity jurisdiction. C. Apply federal evidentiary rules unless the state rule is outcome determinative under the Erie Doctrine. D. Apply whichever rule the judge believes is most equitable. Answer: C. Apply federal evidentiary rules unless the state rule is outcome determinative under the Erie Doctrine. Explanation: Under Erie R. Company v. Tompkins 304 U.S. 64 1938, federal courts apply substantive state law and federal procedural rules in diversity cases. However, if the state rule is outcome determinative, it may be applied to prevent forum shopping and ensure fairness. Hannah v. Plumer 380 U.S. 460 1965. Question 10. A defendant in a federal case moves to dismiss the complaint for lack of personal jurisdiction. The plaintiff argues that the defendant has minimum contacts with the forum state based on an interactive website that allows sales to residents of that state. Which test should the court apply to determine whether personal jurisdiction is proper? A. The effects test from Calder v. Jones. B. The sliding scale test from Zippo Manufacturing Company v. Zippo.com Inc. C. The reasonableness test under Worldwide Volkswagen. D. The stream of commerce test from Asahi Metal Industry Company v. Superior Court. Answer: B. The sliding scale test from Zippo Manufacturing Company v. Zippo.com Inc. Explanation: For internet-based activities, courts often use the Zippo sliding scale test, which categorizes websites as passive, interactive, or fully commercial to determine jurisdiction. Zippo MFG Company v. Zippo.com Inc. 952 F. Sup. 1119 W. D. Part 1997. Question 11. A plaintiff files a civil action in state court. The defendant, a corporation incorporated in Delaware but with its principal place of business in Texas, removes the case to federal court under 28 U.S.C. SS 1441, arguing diversity jurisdiction. However, the plaintiff is resident of Texas. Which of the following best describes the correct legal outcome? A. The case remains in federal court because diversity jurisdiction applies. B. The case is remanded to state court because removal was improper under the forum defendant rule. C. The case is dismissed because the plaintiff did not initially file in federal court. D. The case remains in federal court, but only if the amount in controversy exceeds $75,000. Answer: B. The case is remanded to state court because removal was improper under the forum defendant rule. Explanation: Under 28 U.S.C. SS 1441 B2, defendant cannot remove case to federal court based on diversity jurisdiction if the defendant is citizen of the forum state. Since the corporation's principal place of business is in Texas, it is considered Texas citizen, making removal improper. The case must be remanded to state court. Question 12. A federal judge issues a preliminary injunction against a company, preventing it from distributing a disputed product. The defendant seeks an immediate appeal. Under what circumstances can the defendant appeal the injunction before the case is fully resolved? A. Interlocutory appeals of injunctions are always allowed as a matter of right. B. The defendant must first seek certification from the district court under 28 U.S.C. SS 1292 B. C. The defendant must file writ of mandamus with the Supreme Court. D. The appeal is only available if the injunction would cause irreparable harm to the defendant. Answer A. Interlocutory appeals of injunctions are always allowed as a matter of right. Explanation. Under 28 U.S.C. SS 1292 1. Interlocutory orders granting or denying injunctions are immediately appealable as matter of right without requiring certification from the trial court. This allows appellate review of preliminary injunctions even before final judgment. Question 13. In a federal civil trial, the plaintiff presents expert testimony to support damages claims. The defendant moves to exclude the testimony, arguing that the expert's methodology is unreliable. The court must decide whether to allow the testimony. Which legal standard applies in determining the admissibility of expert testimony? A. The general acceptance test from Frye v. United States. B. The Daubert standard from Daubert v. Merrill Dow Pharmaceuticals, Inc. C. The best evidence rule under the federal rules of evidence. D. The burden-shifting framework from McDonnell Douglas Court v. Green. Answer B. The Daubert standard from Daubert v. Merrill Dow Pharmaceuticals, Inc. Explanation. Under Daubert v. Merrill Dow Pharmaceuticals, Inc. 509 U.S. 579, 1993, federal courts act as gatekeepers to ensure that expert testimony is based on reliable principles and methods. The court considers factors such as testability, peer review, and error rate. Question 14. A plaintiff files a federal lawsuit and personally serves the defendant with the summons and complaint. The defendant files a motion to dismiss for insufficient service of process, arguing that the plaintiff personally serving the defendant violates Rule 4 of the Federal Rules of Civil Procedure. Is the defendant correct? A. Yes, because a party to the case cannot personally serve a defendant under Rule 4. B. No, because personal service is always valid under federal rules. C. Yes, unless the defendant waives service under Rule 4D. D. No, as long as the defendant received actual notice. Correct answer A. Yes, because a party to the case cannot personally serve a defendant under Rule 4. Explanation. Under Rule 4C2, a plaintiff cannot personally serve a defendant. Service must be performed by a non-party over 18 years old. If service is defective, the court may quash it and require proper service. Question 15. A corporation is sued in federal court and disputes personal jurisdiction. The corporation operates a nationwide online store but has never directly conducted business in the forum state. Under what circumstances is the court likely to find personal jurisdiction? A. If the corporation specifically targeted consumers in the forum state. B. If the corporation's website is accessible from the forum state. C. If the corporation has registered agent in the forum state. D. If at least one resident of the forum state purchased product from the corporation. Answer A. If the corporation specifically targeted consumers in the forum state. Explanation. Personal jurisdiction requires purposeful availment, meaning the defendant must have purposefully directed activities at the forum state. International Shoe Company v. Washington, 326 U.S. 310 1945. Simply having a website is not enough. Question 16. In a federal court case, the defendant believes the plaintiff lacks standing. What is the key element the court must evaluate to determine standing? A. Whether the plaintiff has a strong legal claim. B. Whether the plaintiff has suffered a concrete and particularized injury. C. Whether the plaintiff resides in the forum state. D. Whether the case has been filed in a timely manner. Answer B. Whether the plaintiff has suffered a concrete and particularized injury. Explanation. Under Article Rome 3 of the U.S. Constitution, standing requires 1. Injury in fact, 2. Causation, and 3. Redressability. Lujan v. Defenders of Wildlife 504 U.S. 555 1992. A plaintiff must show a real injury, not just a theoretical grievance. Question 17. A party wishes to amend their complaint after the defendant has filed an answer. Under Rule 15a, when can a court deny leave to amend? A. If the amendment would prejudice the opposing party. B. If the amendment introduces new legal claims. C. If the amendment is made within 21 days of the answer. D. If the amendment seeks to clarify existing allegations. Answer: A. If the amendment would prejudice the opposing party. Explanation: under Rule 15a, courts freely grant leave to amend unless there is undue delay, bad faith, or prejudice to the opposing party. Foreman v. Davis 371 U.S. 178 1962. Question 18. In a civil case, the defendant moves for summary judgment. What standard must the court apply to determine whether summary judgment is appropriate? A. Whether the plaintiff can prove their case beyond a reasonable doubt. B. Whether there is a genuine dispute of material fact requiring trial. C. Whether the defendant has presented a strong defense. D. Whether the case is likely to succeed at trial. Answer: B. Whether there is a genuine dispute of material fact requiring trial. Explanation: under Rule 56a, summary judgment is appropriate if there is no genuine dispute of material fact and the moving party is entitled to judgment as a matter of law. Courts view the evidence in the light most favorable to the non-moving party. Question 19. A plaintiff files a lawsuit in federal court alleging breach of contract. The contract contains a forum selection clause that designates state court in a different jurisdiction as the exclusive forum. The defendant moves to dismiss for improper venue, citing the forum selection clause. How should the court rule? A. Deny the motion because a forum selection clause is never binding in federal court. B. Grant the motion and dismiss the case because the forum selection clause is controlling. C. Transfer the case to the designated state court under 28 U.S.C. SS 1404a. D. Transfer the case to another federal court in the designated jurisdiction under 28 U.S.C. SS 1404a. Answer: D. Transfer the case to another federal court in the designated jurisdiction under 28 U.S.C. SS 1404a. Explanation: under Atlantic Marine Construction Company v. U.S. District Court 571 U.S. 49, 2013, valid forum selection clause should generally be enforced by transferring the case to the designated federal forum under 28 U.S.C. SS 1404a rather than dismissing it outright. Question 20. A plaintiff wins a civil case and is awarded damages. The defendant refuses to pay and transfers assets to a relative. The plaintiff seeks to enforce the judgment. What legal remedy is most appropriate? A. File a motion for a new trial. B. File a writ of mandamus to compel payment. C. Seek a writ of execution to seize the defendant's assets. D. File an appeal on the basis of non-payment. Answer: C. Seek a writ of execution to seize the defendant's assets. Explanation: writ of execution is a legal tool that allows prevailing party to enforce judgment by seizing the defendant's property to satisfy the debt. Federal Rule of Civil Procedure 69a governs this process. Question 21. A defendant in a federal lawsuit files a motion for judgment as a matter of law (J-Mol) under Rule 50a after the plaintiff presents its case at trial. The motion is denied. After the jury returns a verdict against the defendant files a renewed J-Mol motion under Rule 50b. Which of the following is true? A. The renewed J-Mol motion is improper because J-Mol must be filed before the jury deliberates. B. The renewed J-Mol motion is only allowed if it was originally requested under Rule 50a. C. The court must grant the renewed J-Mol motion if the jury verdict was unreasonable. D. The renewed J-Mol motion is automatically denied if the jury reached a unanimous verdict. Answer: B. The renewed J-Mol motion is only allowed if it was originally requested under Rule 50a. Explanation: under Rule 50b, a party may renew a J-Mol motion only if they first made a Rule 50a motion before the case was submitted to the jury. This preserves the issue for post-trial review. Question 22. A federal district court dismisses a case with prejudice. The plaintiff, believing the decision was incorrect, wants to challenge the ruling. Which of the following is the most appropriate legal action? A. File a Rule 59 motion for a new trial. B. File a Rule 60 motion for relief from judgment based on newly discovered evidence. C. File a direct appeal to the appropriate U.S. Court of Appeals. D. File a petition for hearing in the same district court. Answer: C. File a direct appeal to the appropriate U.S. Court of Appeals. Explanation: a dismissal with prejudice is a final judgment on the merits, meaning the appropriate remedy is an appeal to the U.S. Court of Appeals. Rule 59 and Rule 60 motions are available in limited circumstances, but are not the primary method for challenging a final judgment. Question 23. A defendant in a federal lawsuit files a counterclaim against the plaintiff. The counterclaim does not arise out of the same transaction or occurrence as the plaintiff's claim. How should the court classify this counterclaim? A. Compulsory counterclaim under Rule 13a. B. Permissive counterclaim under Rule 13b. C. Cross-claim under Rule 13g. D. An unrelated claim that cannot be heard in the same case. Answer: B. A permissive counterclaim under Rule 13b. Explanation: under Rule 13b, a permissive counterclaim does not arise from the same transaction or occurrence as the plaintiff's claim, meaning the defendant may assert it but is not required to do so. Question 24. A federal court dismisses a plaintiff's case for lack of personal jurisdiction. The plaintiff refiles the same case in another federal court that also lacks jurisdiction. The defendant moves to dismiss again. Which legal doctrine is most applicable? A. Res judicata, claim preclusion. B. Collateral estoppel, issue preclusion. C. Forum non-conveniens. D. The law of the case doctrine. Answer: B. Collateral estoppel, issue preclusion. Explanation: collateral estoppel prevents relitigation of an issue that was already decided in a prior case, because the first court ruled on personal jurisdiction. That issue cannot be relitigated in another court. Question 25. During jury selection in a federal trial, a party exercises a peremptory challenge to strike a juror based on race. The opposing party objects under Batson v. Kentucky. What must the striking party do to justify the challenge? A. Prove that the juror would be biased. B. Provide a race-neutral explanation for the strike. C. Show that the challenge is permitted under the federal rules of civil procedure. D. Demonstrate that the juror's removal would not affect the case's outcome. Answer: B. Provide a race-neutral explanation for the strike. Explanation: under Batson v. Kentucky 476 U.S. 79, 1986, when a Batson challenge is raised, the striking party must provide a race-neutral reason for the peremptory challenge. If the reason is not credible, the court may reinstate the juror. Question 26. A party in a federal lawsuit refuses to comply with a discovery order. What is the court's strongest available sanction under Rule 37? A. Issuing an order compelling discovery. B. Imposing monetary sanctions. C. Striking pleadings or entering default judgment. D. Ordering additional depositions. Answer: C. Striking pleadings or entering a default judgment. Explanation: under Rule 37b, if a party fails to comply with a discovery order, the court may strike pleadings, dismiss the case, or enter a default judgment. This is the most severe sanction available. Question 27. A plaintiff sues multiple defendants in a federal lawsuit. One defendant settles before trial, and the case proceeds against the remaining defendants. The remaining defendants argue that they should receive a reduction in damages. Which doctrine applies? A. Joint and several liability. B. Contribution and indemnity. C. Claim preclusion. D. Abstention doctrine. Answer: A. Joint and several liability. Explanation: under the joint and several liability doctrine, if multiple defendants are found liable, each can be held responsible for the full amount of damages, even if one settles. Some jurisdictions allow damage reduction based on settlement amounts. Question 28. A plaintiff files a lawsuit in federal court alleging violations of both federal and state law. The defendant moves to dismiss the state law claims, arguing that the federal court lacks jurisdiction over them. Which of the following statements is most accurate regarding the court's ability to hear the state law claims? A. The court must dismiss the state law claims because federal courts lack jurisdiction over state law issues. B. The court can hear the state law claims under pendent jurisdiction, provided they share common nucleus of operative fact with the federal claims. C. The court may hear the state law claims only if the plaintiff files an amended complaint to assert diversity jurisdiction. D. The court must decline to hear the state law claims under Rooker-Feldman doctrine. Answer: B. The court can hear the state law claims under pendent jurisdiction, provided they share a common nucleus of operative fact with the federal claims. Explanation: under 28 U.S.C. SS 1367, a federal court may exercise supplemental jurisdiction over state law claims if they arise from the same set of facts as the federal claims. This is sometimes referred to as pendent jurisdiction, from United Mine Workers v. Gibbs 383 U.S. 715 1966. The Rooker-Feldman doctrine applies only when federal court is asked to review state court judgment. Question 29. A plaintiff in a federal lawsuit wishes to use deposition testimony from an unavailable witness at trial. The defendant objects, arguing that live testimony is required. Under what circumstances may the court permit the use of the deposition testimony? A. Only if both parties agree to use deposition testimony before trial. B. If the witness is unavailable under Federal Rule of Evidence 804A and the deposition meets the requirements of Federal Rule of Civil Procedure 32A. C. If the plaintiff submits an affidavit explaining why the witness is unavailable. D. If the court determines that using deposition testimony will not prejudice the defendant. Answer: B. If the witness is unavailable under Federal Rule of Evidence 804A and the deposition meets the requirements of Federal Rule of Civil Procedure 32A. Explanation: under REP 32A4 and 3 804A, deposition testimony may be used if a witness is unavailable due to reasons such as death, illness, or absence beyond the court's subpoena power. The deposition must have been in accordance with the rules, with both parties having an opportunity to cross-examine the witness. Question 30. The federal trial court issues a judgment. The losing party files a timely appeal, but also asks the trial court to stay enforcement of the judgment while the appeal is pending. The court denies the request. What is the losing party's best legal option? A. Request stay from the appellate court under Federal Rule of Appellate Procedure 8A. 2. B. File new lawsuit to challenge the trial court's decision. C. Seek an injunction from the U.S. Supreme Court to stop enforcement of the judgment. D. Ask the appellate court to vacate the trial court's decision before the appeal is resolved. Answer: A. Request a stay from the appellate court under Federal Rule of Appellate Procedure 8A. 2. Explanation: under FRAP 8A. 2. If a trial court denies a stay of judgment pending appeal, the losing party may request a stay from the appellate court. The appellate court considers factors such as likelihood of success on appeal and potential irreparable harm. Filing a new lawsuit or seeking an injunction from the Supreme Court would be inappropriate.